Got a question on TikTok from someone asking if a landlord can give a 30-day notice to vacate without any prior notice. They've been living there at the property for 8 years on a month-to-month rental agreement. Hi, my name is Rob Wells. I'm the Landlord Warrior on TikTok and YouTube. Please feel free to like, share, and subscribe to our videos. Okay. Assuming that this landlord, we're talking state law, we're not talking about local law. You know, if you're in a local eviction control area and you need to have cause, we're not talking about that. Okay. And for landlords, we're talking if this tenancy is exempt from the Tenants Protection Act. Okay. If that is the case, the answer will depend on a couple of different things. Okay. Because here's the deal. Landlords that are exempt from the Tenants Protection Act still, under Civil Code 1946.1, generally have to give a tenant 60 days or more notice if they've lived in the property for a year or greater. Okay. There is a small exception. Okay. It's codified in Civil Code section 1946.1D. Okay. There's a lot of conditions. First off, if the property is a single dwelling, like a single family home, and the owner is in contract to sell the single family home to a bona fide purchaser of value that's going to live in the home, basically, that is the purchaser's a natural person. And within the last 120 days, an escrow has been open and no notice of termination of tenancy has been given under Civil Code section 1946.1. And the buyer, the purchaser of the property, intends to purchase the property. And if you meet all those requirements, basically, then a landlord could give a 30-day notice to vacate the property. Okay. I'm going to tell you a war story. Okay. Now, I actually had this situation happen to me several years ago. I think it was before the Tenants Protection Act even came into effect here. It was a landlord that was in this situation. They had their property for sale. They had a bona fide purchaser that was going to live in the home. Right. So this landlord gave a 30-day notice, right? Problem was their bona fide purchaser fell out of escrow. Okay. And there was this legal question that came up. Can the landlord still terminate the issue, the tenancy on that 30-day notice? And, you know, I don't know of any reporting cases that have addressed that issue. We were arguing, yes, that the termination could go. But I think if the case was contested, we ended up settling, by the way, in the story here. But if the case ended up being contested, I think that owner would be required to bring the potential purchaser in as a witness and testify that, you know, they had an intent to purchase the property, and for no fault whatsoever of the buyer or the seller, you know, pulling out of the deal, basically the deal fell through. Okay. Personally, I don't like this. I know it's on the books. I know you can use it. I've had in practicing since 2013. I only had that situation happen once. So take it for what it's worth, okay? But generally speaking, no. Landlord generally has to provide 60 days or more notice, okay, per Civil Code section 1946.1. Landlords, if you're contemplating selling property and you need to terminate a tenancy, there are a lot of rules out there, okay? You might be subject to Tenants Protection Act. I've said in these videos before, selling your property is not necessarily just cause, okay? We might be able to use it, but it's not just cause under the state law, okay? So you need to be careful. If you're thinking about doing this and you're in the Northern California area, feel free to reach out. We might be able to help out. Put your comments, questions down below. Until next time, I'll talk to you then. Thanks.